everyone. It is indeed my privilege today to introduce you to Mr. Surjendu Sankar Das. Mr. Das is an advocate on record at the Supreme Court of India and specializes in arbitration and litigation practice. He graduated from NUJS in 2008 and went on to serve as a dispute resolution partner at Shardul Amarchand Mangaldas. He has successfully handled numerous cases before the Supreme Court, various high courts, trial courts, and tribunals in India. Further, Mr. Das has successfully handled several complex international and domestic arbitrations and enforcement proceedings, having appeared before the International Chambers of Commerce, International Center for Alternative Dispute Resolution, and Singapore International Arbitration Center. Currently, Sir is also the Standing Counsel for the State of Goa, panel advocate for GAIL India Limited, counsel for BHEL. He will join us today for a discussion on the theme Nuances of Arbitration Practice, Challenges as a Young Practitioner. Sir, it is our absolute pleasure to have you here with us today.
Thank you, Sujoy and Archita. Is there any other formality that you have to complete?
No, sir, you may take.
Yeah. Thank you and good afternoon, good evening, everyone. So we are meeting over virtual platform. So this is not exactly the perfect way to discuss your opportunity scope in any dispute resolution, but we had no other option because I wanted this to be a very interactive session, but our scope is limited because of virtual platform. But we will, I think we'll deal with all the questions, whatever queries you have in mind. So though I'll try to maintain a flow of my talk. So, it's not very structured, but semi-structured. But if you have some question in between also subject to what the coordinators are thinking, I can accept those as well. So with that, I don't mind if other people switch on their camera also, because otherwise sometimes I feel like I'm speaking to myself. It's like me and my video. Okay, so that's, at least you have some mental relief that I'm speaking to live people. Okay, so with that, I'll start my session. I have prepared a very short slides, but those will be dealing with the nuances of arbitration. And now the topic is nuances, opportunity, and challenges in the practice of arbitration. So I want to break it into two parts. First part, I'll deal with the nuances. Second part, I'll deal with opportunity and challenges, both the aspects. Right now, if you can at least indicate how many of you have participated as an intern during an internship in arbitration. Any raise of hand or any like couple of hands also will be fine, because I don't know how to see everyone's hand. Yeah, I can see a couple of hands. So that's good that you people have participated in the sense you have witnessed how the arbitration happens. And many of you may have participated in the moot court competition also, which had some arbitration law, maybe arbitration law moot only. But moot is slightly different because it's certain aspect of it. But when you have participated as an intern in an arbitration, you get to know what's happening exactly, even if a couple of sessions. So I'll come to that aspect slightly later. First, let me just give you a brief background of what is this arbitration all about, which I'm sure that you have a broad idea. Just a minute. Is it visible to all of you?
Yes, sir.
Okay, so how to operate this? Now?
Yes, sir, it's visible.
Yeah. So, arbitration is an area. Why it's area? It's called alternative dispute resolution. So this is alternative to something. So what is something is important. Is something to the traditional method or mode of dispute resolution. That is the reason it's called alternate, right? Now I have given the features of what are the general features of area. So there you will find that informality is one of the aspects, that it's not very formal, like you don't go to court wearing robe, band. That's one aspect of it. You don't go to court at all. So you are in an arbitration or any other dispute resolution which is alternate. You can be attired in simple formal and go there, and you can control the procedure. It's very important. Like in a court of law, you are bound by the CPC, CRPC, and other regular methods. But in arbitration, what you are doing is completely controlled by the parties, and of course is decided by the arbitrator. And you are involving someone third person, be it arbitration, be it mediation or conciliation, who shall be either adjudicating or trying to bring both the parties to a settlement, the other modes than arbitration. So that's the general concept of ADR. And if you look at the ADR methods, there are a couple of methods which are very popular. First is negotiation, which is not very popular in India, but it's some sort of settlement. You can say that parties are sitting together across the table and deciding their pros and cons and the claims and settling the matter. Second method would be mediation. Mediation is one third person is involved in, maybe 1, 2, 3, doesn't matter. The mediator's role is that to listen to both the parties and give them, like, this is your case, right? It's not about telling them that you settle it, but give a way that this is how the matter can be resolved. And if both the parties decide to resolve in mediation, then only it can be successful. Conciliation is one aspect where the conciliator has some bit of role, more than what happens in mediation. But ultimately the end result is a settlement only. There'll be a settlement agreement by which you resolve the disputes. Last is the arbitration, which is different than the other three. So arbitration involves adjudication of disputes, what you find in court. So these are the popular method of ADR. There are plenty of others, but for our focus, we should be confining these 3, 4 only. The reason why I have laid down other 3 as well, because most of the arbitration clauses you see that there is an escalation clause. So you do conciliation or mediation, then go for arbitration. So why I'm telling you all these things, that you may be wondering this, we are discussing about the scope and opportunity, but unless you know how it exactly works, at least the general information, which you may have little bit idea of, but I'm just highlighting or refreshing your memory what you have learned during your law school semester or your internship. So benefits of ADR, as I said, there's a procedural flexibility is one of the important aspect. So tribunal is not, or tribunal, if not tribunal, is conciliator or mediator. They're not bound by the complex procedure of law, for example, CPC, Evidence Act. Parties can determine that, okay, well, we'll not have a third pleading, like one party will file their claim, other party will file the reply. That's it, and we'll directly go for evidence. There's nothing in between. So you have those kind of flexibilities to decide how to resolve the entire problem and come to an award. Lower cost. Now, cost is very debated aspect, because it is commonly known that arbitration is very costly affair, but which I completely deny, because people see in terms of how they're paying the arbitrator and the counsels. But if you compare this with the court structure, you end up sometimes paying more than what you're paying in arbitration. And when you talk about the cost is always linked to the time. So earlier, what used to happen until 2000, recent amendment, 2015 amendment, when there is no limitation for completion of arbitration. The arbitration used to happen over 6, 7, 8 years. So that's not, it's sort of a court proceedings only. Only thing is that it's informal. So you end up spending money which gives you the feeling that it's very costly affair. But with 2015 amendment introduction, when you have some certain time limits to conclude the arbitration, the cost of arbitration is also to some extent is capped, because you have fourth schedule in the Arbitration Act where arbitrator has to be paid a specific fee. If it is institutional arbitration is slightly different. For international commercial arbitration, of course, arbitration fee and administrative charges are slightly higher on site. Similarly, the council's fees as well. But if you compare, like if you are getting a resolution within a 2 years time, or maybe 2.5 years of time, if you compare that similar setup in a regular court proceedings, it will take at least 5 to 10, maybe 10, more than 10 years, depending on the jurisdiction, which place, which high court, which lower court you are. So if you talk about today's date, the cost aspect, arbitration is much more cost effective than the general litigation. Why we say it's less complex? So I'm generally discussing about ADR, but focusing on arbitration. Now, coming back to arbitration again, it's less complex because you don't follow the standard process of the filing and other stuff, and kind of procedural requirement which are compulsory for court. You don't have to do it. So it's less complex from that aspect. And also, if consider this particular aspect, that in a day, a court will have 50 matters on the roster to decide. In arbitration, you're getting a full concentration by the arbitrator, if it's a mediation or conciliation also. So your case is the only case, maybe 2 cases the arbitrator has. So they're deciding is with full focus, full preparation and everything. So those are the advantages which gives you less complexity involved in the entire process. So that we have to keep in mind. Confidentiality is one aspect that, not all commercial proceedings, you can say that everything is confidential. You can have in-camera proceedings. So in arbitration or conciliation, mediation, you have a closed room setup when the parties are discussing their commercials and everything, which cannot be taken out to outside. Sometimes, the question comes when you come to court after completion of arbitration, whether confidentiality remains or not. So that's one aspect which is debatable, but frankly speaking, arbitration, conciliation and ADR mechanism is much more confidential than any other proceedings. And in commercial matters, when you are discussing about courts, price figures and certain aspects of commercial terms which you don't want it to be in public domain, so this ADR mechanism is the perfect mode, because then confining it to certain stakeholders involved in the adjudication process. And last important aspect is that you are involving someone neutral, third party, in the sense he's supposed to be neutral, and there are certain aspects. If he's not neutral, what options you have and all. But in court, you don't have a choice, but you have to go with a particular judge who has a roster to decide this kind of matters. So take it back to your arbitration setup or some adjudication setup. So when matter is a complex matter, you will have some issues related to construction, particular constructions also. So you can choose, parties can choose who will be the arbitrator or the conciliator who has domain expertise on this particular subject. So these are the general benefits, what you should keep in mind when entering into an arbitration or ADR field, that, well, these are the things I have. And believe me, this has an important aspect, because this is not to give you sort of an academic exposure, but this is a practical exposure. Once a client comes to you, for example, a corporate client also, they want to have an arbitration agreement. There's no dispute, but there's an arbitration agreement. So they may ask you a simple question: tell me, Mr. Counsel, why you're insisting me to have an ADR clause in your agreement? So you have to justify. So unfortunately, we have a segregation of corporate and dispute resolution lawyers. So we are part of litigation dispute resolution. So when I was in a law firm, then corporate teams will approach me to tell me why this particular clause should be drafted like this, what are the pros and cons, what arbitration clause should be there. So ultimately, this may sound theoretical, but when you are into the profession, these theories, which has a practical aspect, are of immense significance, because you can guide your client what to do and what not to do. Right. So with that, I'll take you to next slide, which gives you the evolution of arbitration law. Just to keep in mind that it's very old trend, the arbitration. So I could trace it in 1772. There's a Bengal regulation which has an aspect of arbitration. There was 1899. Then 1940 onwards, everyone knows that there has been Arbitration Act full-fledgedly. 1996, everyone knows. 2015, you have some amendment, which are path-breaking amendments, and that created confusion, that created advantages, not disadvantages to my opinion, but there are a different evolutionary aspect which has been derived from 2015 amendment. Certain defects have been cured in 2019, and some more in the pipeline to be notified, and in terms of timeline, etc., etc. If you go through the act, you will understand the relevance of these amendments. So features of arbitration, try to draw down a couple of features which may be relevant for you to know. It's a contract. Arbitration agreement is a contract between two parties. So contract may have an arbitration clause, which is called the arbitration contract, by a separate document, which will be called arbitration agreement. So it's possible that way. And of course, it's voluntary. Parties both have to decide that we'll go for arbitration. Then the arbitration can happen, and parties can agree to their procedural rules, language, applicable law, etc., etc. And time and cost aspect I've already discussed. And certain disputes cannot be arbitrated, which I think most of you have heard of: Booz Allen and the subsequent follow-up judgments, trust disputes, tenancy disputes, IPR disputes, which all can be arbitrated, which cannot be arbitrated. And things are changing also. Earlier the concept was that why IPR disputes cannot be arbitrated, but the Bombay High Court decisions, they said that certain aspect which is in personam can be arbitrated. So and of course, criminal matrimonial matter cannot be arbitrated because those are in rem proceedings, in rem in nature. So these are the general features of arbitration. When you go through the provisions of the case laws, you will understand what is the implication of this. Now coming to more, I'm gradually trying to come to the more interesting parts. So there are two modes of arbitration. One is institutional arbitration. Second is ad hoc arbitration. In India, we have mostly the ad hoc arbitration. Institutional arbitration, I think they share, I think, 5% of the total arbitration, whatever is happening in India so far. So the reason being that the presence of institutions are not very strong in India, except SIAC, ICC, or a couple of institutions. There's hardly any prevalence in India. And if you take the name of Indian institutions, we hardly had any institutions which was active. We had ICADR arbitration. I remember when I used to do arbitration in 2008 to 10, that time ICADR Delhi has 5 arbitration, just imagine. Out of 5, 3 only I was only doing. So that kind of situation. So Indian institution didn't have a robust presence at all. With MCI, they have been trying to make their presence in India gradually. They're doing a good job. But there's one institution, I think it's called ICA, Indian Council of Arbitration, under FICCI. That also didn't find any good presence in India. So that's the reason institutional arbitration didn't have much growth. one way to think about is that some clients or corporates, they think that institutional arbitrations are costly. So costly in the sense, if you look at your fee schedule of SIAC or ICC, for example, there's a you can calculate that also. If you take, for example, $1 million and put that in the calculator, you'll find some hefty amount as arbitration and fee and administrative fee. So that gives a fear into the client's mind, those who are not accustomed to arbitration and institutional arbitration. For example, recently I was doing an arbitration, so she had done the first time international arbitration. It was a SIC arbitration. So we gave an estimation of the fee. That's how it works. So it was, if I calculate in INR, it was approximately 75 lakhs as arbitrator fee. So when we started the arbitration, now when we filed the claim, so we found that the claim could be extended a bit more. So initially we thought of X amount. When we filed the statement of claim, it became X plus Y. So that, of course, in favor of your client only. But at the same time, your arbitration fee also increased. So that gave sort of anxiety in client's mind. He said, you told me this is the fee, why it's increased? Then you have to reduce your claim amount. So fee is one aspect which has an implication in client's mind. And of course, that's one of the reasons why parties, they generally not avoid, they want to stay away from institution, thinking that is very expensive. So so that is one of the reasons why the institutional arbitrations are not prevalent in India. The trends are changing because all these high-level committee, on the basis of which these amendments have happened, they are focusing on institutional arbitration. There is a inherent advantage, if I can say so, in institutional arbitrations. If you go through the high-level committee report, you will find those pros why parties should opt for institutional arbitrations. And once you're in practice, you'll get to know more what is institutional arbitration, how it functions. So generally speaking, it's very structured. They have a rule. For example, SIC has their rules. ICC, they have their own rules. You have to follow that rules, right? And they appoint specialized arbitrators, which is sort of not, I would not say missing in ad hoc arbitration, but sometimes you're clueless whom to appoint arbitrator, and you end up appointing a retired judge who has been referred by one of your friend. So ad hoc arbitration, and institutional arbitration, I think I've gone too far. I just go back a little bit and say that ad hoc arbitration is that when arbitration clause does not mention that this arbitration is governed by any particular rules of ICC, SIC, MCIA, whatever it can be, then what happens, parties can choose the arbitrator. If it is sole arbitrator, parties can choose that Mr. X will be an arbitrator. If there's a panel of 3 arbitrator, so one party can say that Miss X will be my nominee arbitrator. Another party appoints another arbitrator, and both the nominee arbitrators appoint the presiding arbitrator. So that's an ad hoc setup because it is not supervised by any institutions. Is done by the parties themselves. And of course, if you fail to appoint, then you approach High Court or Supreme Court under Section 11 for appointment. So that's an ad hoc arbitration. Anything like whosoever is being appointed is party's choice, and there's no fixed procedure to do that. You just simply follow your contractual stipulation. That's it. So in comparison to that, once you're coming to institutional arbitration, so there's a set set rules of the institution. You are bound to follow that. Why? Because parties have agreed to follow that rules. So once parties choose a particular rules, maybe SIC or ICC, in such situation, what happens? You simply follow the rules. So if your contract says that parties will try to, if it is a sole arbitrator, one arbitrator, parties can by agreement say that we'll jointly suggest or nominate the arbitrator. it is done. Then appointment is done by the ICC court or SIAC secretariat. So they are appointing. So what they do, they check that parties have chosen particular person, whether he fits the requirement or not, so that some sort of a supervision is there. And parties can also say that we are not able to agree to a particular arbitrator, let it be decided by SIAC or ICC court. So they leave it to the court and they appoint an arbitrator. You can have an objection with regard to his credential, maybe whatever disclosure he has made, but appointment is done by the institution. Similarly, for the purpose of following the process of arbitration, you are following the rules provided in the rule book. In comparison to that, if you're going to ad hoc arbitration, there is no rule book, right? Parties are deciding, which is always sort of changed day to day. Like parties are not able to follow it, they change it, they do something random. So this is ad hocism, which is not good for any arbitration. Sometimes is good. There are advantages, disadvantages, both. But mostly, I find that institutional arbitrations are more proactive, and you end up having a structured arbitration. That's the institutional arbitration, and that's why those who are in arbitration practice, they generally recommend institutional arbitration to the parties when they come for suggestion what to do, what not to do. So my next slide is on this is a general overview of the Arbitration Act. This is our mother act, Arbitration and Conciliation Act. It has three parts. One is domestic award, second part is foreign award, third is conciliation. So when I say domestic award, it deals with the arbitration which happens in India, seated in India. So what is seat and venue? You may have heard of it, the debate, but I'm not getting into the debate right now because we have to discuss something more. Part 2 is the foreign award, and part 3 is conciliation. But one important aspect I tell everyone, like to my juniors also, that never confuse between what is domestic arbitration, what is foreign arbitration, and what is domestic award and what is foreign award. So an arbitration which is seated in India, part 1 applies, right? It can be between one Indian party and one foreign party. It can be between, of course, between two Indian parties. So part 1 applies for both the cases. If the seat of arbitration in India, seat or place of arbitration in India. So in cases one party is Indian and one party is foreign party, is called international commercial arbitration. But since your seat of arbitration is India, Delhi, Mumbai, whatever it may be, your part 1 compulsorily applies, right? Now, if you talk about what is part 2, it's not that it's a foreign arbitration, part 2 applies. That's not the case. Part 2 is only for predominantly for enforcement of foreign award. So you get an arbitral award which is passed outside India, where seat is not in India, seat is in London, Singapore, Paris, wherever it may be. You are bringing that award to India. You're trying to enforce the award. Why will enforce the award in India? If some assets are lying in India, right? So that's an interesting point. I had handled one matter. Is both the parties were from Mauritius, so there's no Indian connection at all. The award was passed in India, Mauritius, and I think under ICC rules only. And what happened? Some part of enforcement had to happen in India because one of the parties had some assets in India. So therefore, we decided to enforce partly in India. So we applied under part 2 of foreign award. Part 2 of the Indian Arbitration Act, because it is a foreign award for the purpose of part 2, and you can apply in India. And this is very interesting is that section 9, which is interim relief, that applies in such situation. So we applied for interim reliefs also. Some certain relief was granted, then higher court rejected, then we succeeded in Supreme Court. Many things happen. So there's a distinction between how you apply part 1, part 2. Part 3 is conciliation. Is not part of our topic of today. That's the general background of your Arbitration Act. And now most important aspect, what I have been telling you, is that the law involved in arbitration. There are multiple laws which are involved in arbitration. First is law governing the contract. So, for example, your contract between party A and B. I'm taking an example of party A, Indian party, party B is a foreign party. So you decide that law governing contract will be Indian law. What is that Indian law? Indian Contract Act 1872. But you can decide that your law governing arbitration, which is separate and severable from the main contract, will be governed by different law, not Indian law. So it can be by, for example, Singapore law. You can say so. Now, if you have chosen Singapore as a seat of arbitration, and you say that law governing arbitration will be Singapore law, it can be London law as well, right? So there are two different laws which are playing all, together in an arbitration, and also simultaneously you have a law governing the procedure of arbitration. So there you can, for example, you can choose. We can choose SIAC rules. You can choose any other rules. What happens if you're having an arbitration, for example, in London? Just hypothetical situation, it happened with me also. Indian party, foreign party, you are having arbitration in London, and your law governing contract is Indian Contract Act. Your law governing arbitration is London English Arbitration Act, is 1996. They follow the UNCITRAL model. And your law governing arbitration process, they decided to have SIAC. You can do so. So you see that interplay between three different laws altogether, but coming to some sort of equilibrium and make an arbitral award which is enforceable. So that's the beauty about arbitration. And think in a normal suit perspective, what happens if there's no arbitration clause? So one party is Indian, one party is a foreign party. Of course, if you have to approach against a party, against a foreign party, if you have to go to their court, you will feel that their courts may be biased against you. Similarly, other side may feel that if you approaching Delhi High Court, maybe Indian courts are biased towards the Indian party. So there is a conflict, and thought process is different. So therefore, if parties have an arbitration agreement which has the interplay of two laws, but is adjudicated by a neutral forum, right? So that's the advantage of arbitration. And more importantly, if you look at the enforcement aspect, if I'm talking about enforcement of foreign award, arbitral award passed in any other jurisdiction, whether it can be enforced in India or not. So there's a New York Convention, if you are aware of, part 2 deals with New York Convention as well as Geneva Convention. It's mostly New York Convention. In New York Convention countries, anywhere in the New York Convention country, you can enforce that arbitral award. It's very important. And of course, you must have some reciprocal arrangement. For example, an arbitral award passed in London can be enforced in India, because both the countries are signatory to New York Convention, and both the countries have reciprocal arrangement. So countries say that, okay, I'll allow to enforce the award passed in your country in my country. So that's the arrangement we have. There's a notification, so it can be enforced. So universal enforcement is very important, and that's the heart and soul of any international commercial arbitration. So far as domestic arbitration is concerned, you shall not have interplay of so many laws. But since we're discussing about arbitration in general, it's very important to know how it happens in ICA, International Commercial Arbitration. I think I'll have just one or two more slides. See, appointment of arbitrators is one aspect. As I said, it can be happening even ad hoc arbitration by parties themselves, or if the parties fail, it happens through court in a domestic setup. In institutional arbitration, arbitrator appointment only happens through the institution. You can't go to court, right? So that's the general concept of appointment of arbitrator. Now, at what stage, to what extent arbitrator, the court can look into the whether there's arbitration agreement or not, those are debatable aspects, and there are so many judgments till 2021 that court will look into the prima facie existence of arbitration agreement and go ahead to appoint the arbitrator. So those are the precedents, the jurisprudential aspect. I'm not touching those, but appointment can happen through either court or through institution. If I say court, of course, not directly court, parties can do themselves as well. Now, the penultimate slide is on the steps of arbitration. It's very important for all of you to know, to understand how the arbitration practice is done. And there, I'll explain the challenges and opportunities. Something can be derived from this as well. So first thing, you say that arbitrator is not bound by CPC or Evidence Acts. That's the cardinal principle, and it's written in the Arbitration Act itself. Parties can decide their procedure. I've already said so. Those are nothing to do with steps, but I'm telling the principles. Now, the way arbitration happens is very simple. So there's a contract in place. You have an arbitration clause or arbitration agreement. There's a breach of contract. So non-performance, non-recovery of dues, something like that. Any breach has happened. So the defaulting party is warned by the other side that please cure the defect, else I'll take the steps, I'll recover, I'll terminate the contract, blah, 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 blah. So those are the steps, sort of default notice sent, not cured. Then there is a breach. Therefore, once there's a dispute in existence, keep in mind, there has to be some dispute which can be arbitrated. So once there's a dispute in existence, the party who will be the claimant shall invoke the arbitration, which is called notice invoking arbitration. We call it NIA. Section 21 is relevant. So once you have the disputes, you invoke arbitration by way of notice invoking arbitration, right? Once you invoke the such notice, your arbitration has commenced. Keep in mind, it has a limitation aspect, because once you invoke the arbitration, your limitation stops running. That's another chapter altogether. I can see some questions. Okay, let me just finish the steps, then I'll take these questions. Yeah, first is notice invoking arbitration is sent, and therefore arbitrator appointment happens. It may be by mutual consent, by institute, by court, whatever it may be. The tribunal is constituted, and thereafter the next step is the pleadings. Now, pleadings, if you say pleadings, the first pleadings which comes is statement of claim. So you set out your claims. What are you claiming in the arbitration? Right. Now, in reply to statement of claim, what comes is that statement of defense. It's called SOD. So along with the SOD, the respondent can also have counterclaim. So he files a counterclaim. So thereafter, the claimant files rejoinder. Sometimes it's allowed, sometimes not allowed. And essentially is the reply to counterclaim, which is also statement of defense to the counterclaim, right? So this is the pleading in an arbitration. Rejoinder is always not necessary. The tribunal grants permission, and it happened with me, like an ongoing arbitration. So I filed a statement of claim, other side filed statement of defense, I filed rejoinder, other side took liberty to file sir rejoinder. So because of the facts of the case, so it was allowed. But these are the steps for the completion of pleadings. So you file the documents as well with the pleadings. You can file subsequently as well after the completion of pleadings. There are stages. Once pleadings and documents are filed, then the tribunal frames the issues. Issues are of two types: issues of facts, issues of law, right? So factual issues, for example, in an arbitration, other side has filed a document, which I said that is forged document. I denied that document. So first, one of the factual issue could be that whether the such document was forged or is not in existence. There's a factual issue. Legal issue, for example, is framed like whether the claimant is entitled to loss for damages for X amount, so on and so forth. So there's a legal issue, right? So those are issues which have been framed. Now you go for the evidence stage. In evidence stage, it's called witness statements. So first, claimant and respondent, both of them file their evidence, and once they file the evidence, the cross-examination happens. So first, respondents counsels cross-examine claimants witnesses, and thereafter the other side cross-examines. And there are also expert witnesses. Sometimes parties can appoint, arbitrator can appoint the expert witnesses. So that's part of the evidence step. Once the evidence is completed, then you have the argument stage. Argument has two aspects. One is oral argument, second is written submissions. Post hearing, after you make the oral submissions, you have the written arguments. So that's how you complete the arbitration, and thereafter award is reserved, award is passed. Now there is challenge procedure, appeal and enforcement. That itself may take 3-4 hours to discuss if we get into it. But generally, after arbitral award is passed, invariably, I'll not say generally, 99% awards a challenge, unfortunately, in a court of law under section 34. They may not succeed, but of course challenge has become a routine thing, and therefore there are so many conditions which have been put under 2015 amendment. So that's the next step of it. But I find meet in enforcement and challenge as well, because once it goes to court, to how to tackle that, and if you are in successful party side, then you're better off. But if you are respondent, losing party in section 34 challenge, then you have trouble days. So that's how the arbitration happens in India under Indian Arbitration Act. I will stop sharing the slides. Coming back to our second aspects of challenges and opportunities. But before that, I think I'd like to see a couple of questions. What are the kinds of advisory and drafting skills, Subhajit has asked, skills required as an arbitration lawyer, and how much does it compare the litigation? How can one operate for the same at the prepare for the same at the law school level? Yeah, see, unfortunately, the scope of our learning, what I also learned in law schools, there you don't get the practical exposure of drafting, because it can't be also. Like what happens, you're doing internship for example 1 month. No lawyer will entrust you to draft sort of a statement of claim and rely on it completely. You can try to do a good job which will assist your your senior whom you're helping, but he will not completely depend on you, because it has certain intricacies and it's very difficult to explain you within 1 month of time. But of course, for example, I have entrusted to my interns certain drafting which is doable within a 1 month time only. So that is one aspect what you can learn during internship. If you're studying, you're doing a semester, I don't think you'll get a practical exposure of drafting in arbitration or in court, unless you're involved with some lawyer regularly whom you're helping in court on arbitration. But if you are trying to draw a distinction between drafting in arbitration and court, there is a stark difference. Let me tell you, there's a stark difference, but unfortunately, we don't follow that. The drafting in arbitration is very informal. In court, drafting is very formal, right? So people mix it up. What happens in India, we don't have a distinction between those who practice in arbitration, those who practice in court. So therefore, it's all mixed up thing. What you see in arbitration is a reflection of what happens in court. I'm talking about the style of drafting. So I'm not going to language. Language varies from person to person. The style of drafting is very important. So, and that you master with time. That takes time. So what you are learning during your internship or law school, that will help you definitely. But keep in mind, the predominant skill what you should have is to write simple, short sentences. That's it. You must read all the documents, all the papers, and prepare a pleading which is understandable by everyone. Don't make it a complex language. And one of my junior used to write a paragraph or sentence. I said, why? You can split into three sentences. You can do that, right? You do that way. It's easy to understand. So it's not that distinction between litigation and arbitration is that no, in court you have to write a big para. Not like that. But people have unfortunately followed it. So for example, if I am filing a pleading in court, right, I also try to follow simple language, but certain aspects, for example, if someone will start with that, respond number one, some languages which are very intrinsic to your litigation, your court practices, that you have to follow. Otherwise, language should be very informal and simple. The simplicity of the language, and it should not be having the double meaning. A sentence should be construed in only one direction. If it is not the case, you are in trouble. Other side will find out something out of that pleading and make use of it. So therefore, drafting skill is the most important thing. And in arbitration practice, written advocacy is the most crucial. Keep in mind, the court practice is more of a oral advocacy. Written things are not minutely, detailedly checked by the courts. Of course, it does at certain point. But in arbitration, what you are writing is very, very important. Not in arbitration. Even if you go for Section 34, challenge stage. What happened in one matter? I was handling Section 34 challenge before Delhi High Court. I didn't have the opportunity to do the arbitration. So a question comes from the judge. Mr. Counsel, tell me where you have written this in this statement of claim. So I started flipping the pages. I found a blick reference somewhere that doesn't help me, right? So what you have written in arbitration, that written pleading becomes important not only in arbitration but subsequently also, right? Now, when you were in law school, how you are preparing, as I told you, of course, knowledge of law is important. But if you are able to assist your senior wherever you are interning, do that and volunteer to draft something. I remember one of my interns had drafted one application in SIAC arbitration. The language is definitely I had to modify, but I got a flavor what he intends to say. So that theme I had in mind, I had to utilize that. So of course you will be able to help your seniors if you are volunteering to draft something. Second question is, can individual focus solely on arbitration matters from the beginning, or they would need to diversify first and then specialize in arbitration? So see, this second question is very important. See, arbitration is a specialized uh, area of law. That's how you understand, right? If you get inside the arbitration, there's a super specialization also. So there's no end to it. So in arbitration, you have treaty arbitration, you have construction arbitration, you have shareholders dispute, you have oil and gas. So yeah, I remember I recently assisted a law firm based out of Oman. Uh, no, sorry, not Oman. It's Oman only. So the arbitration law is it's there's no connection with Indian law. So it's civil law country. So it was was held in Oman. I held in arbitration because the arbitration was oil and gas. There was a drilling of by rig. There's a pipe, for extraction of oil. So I have specialization in oil and gas. I had helped that law firm to complete the arbitration. They recently succeeded in the arbitration. I got to know. So in the sense, so you may have specialization, super specialization as well, but that comes one by one. Now, if someone says that, well, I'm getting into arbitration practice, so that's my forte, I'll do arbitration, nothing else. That's one way confines your scope, your thought process, I must say. So I have experience, multiple forum of law. In fact, I have appeared more than 12 high courts in India. And that doesn't, they don't deal with only arbitration. They deal with many matters, starting from mines, starting from electricity. It can be anything, shareholders dispute, maybe a simpliciter for enforcement of US judgment in India. It has no connection with arbitration. So those give you exposure to understand, that nurture your thought process. Is very important to know those kind of areas. Then gradually you can super specialize in arbitration. And that's how we practice. If you look at Indian lawyers, we don't have a separate bar for arbitration, what you call arbitration bar. So you approach any lawyer in India, they will say they do everything under the sun. That's also not one way to good to say that I do a criminal, civil, everything, whatever comes to me. That gives you sort of, you lose focus on certain aspects, but it has a plus point as well. But what I feel is that you should have a moderate approach, that you are not confining only in arbitration, which you can't do also, because once you in arbitration also, you may have section 11 for which you go to court, you may have section 9 for which you go to court, you have section 34, you go to court, 37 court, section 27 court, you have to go to SLP also, after you lose everywhere, to court. So if you have a mixture of all the forum, it helps you. And when you say that Evidence Act and CPC, they do not apply to arbitration, don't take it by heart that I'll not read Evidence Act and CPC. Yeah? So the principles do apply. For example, how to rebut a pleading, or how to accept a piece of evidence, what to prove, what not to prove. These are all evidentiary rules. So if you ignore Evidence Act, you can't be a good arbitration lawyer as well. For a very recent example, not name, a senior advocate, he told me advice that, no, Surjendu, you have to lead evidence in all these aspects. I said, no, sir, that's not the law. Evidence law is that the facts which are disputed, I have to lead evidence on that, right? If something is admitted, I don't need to. So where is this coming from? These are evidentiary rules which you'll find in Indian Evidence Act. And if you practice general litigation as well, it will sharpen your mind how to approach in evidence. For example, a cross-examination as well. If you look at cross-examination in court and arbitration, there is a stark difference. There ought to be a stark difference, but unfortunately in India, we make it all the same. Guys typing. The way it happens, I'll tell you. I'll give you two comparisons that will give you an idea. So in court or regular arbitration in India, so one typist is sitting. So I throw a question to the witness. So then the arbitrator listens to it. He may change the question. The typist writes the question. Sometimes I find that question slightly different than what I exactly said. So the question comes slightly different. After reading the question, the witness answers the question. So he answers something. So it is supposed to be typed, but the arbitrator has some value addition. So something is typed which may not have answered only, maybe something differently answered. It can happen. So what is being questioned, what is answered, maybe slightly different than what exactly has happened. The same thing unfortunately followed. This is a court practice because there the judge has to sort of conduct the cross-examination. But in arbitration, there's no such rule, but we end up following up the court practice. I'll give an example. Recently, I've done an arbitration. It was an international commercial arbitration. It had involved 3 jurisdictions. My witness was from Bombay. I told them to come to Delhi. Other side witness, one was from Delhi. One witness was from New York. One witness was from Germany. And arbitrator is sitting in Singapore. Just imagine. So we had 2 days arbitration, just 2 days arbitration. First day arbitration, we started in India time. Approximately, we started late because of a jurisdictional issue. We started at 11 o'clock. We wrapped up the evidence at 9:30. And by that time, the cross-examination of 3 factual witnesses and 2 expert witnesses happened. Total 5 witnesses were examined by way of transcript facility that we don't have in India. I coordinated with Singapore. They had some transcript, online transcript. They had provided service, hefty charges, but they really helped to complete the evidence. Now take this complete setup in Indian arbitration, what I just telling you, that 5 witnesses would have completed their cross-examination, if not in 3 months, but at least 2 months. Because one day, in a day, you can maximum ask questions 50 to 60. Thereafter, everyone gets tired. And how long you will give dictation and type and this, that, people get tired. So thereafter, next date comes after maybe 1 month. So everything is delayed because of the entire facility and the structure we follow. And there, in international arbitration, we have 350 pages of transcript overnight. 9:30 we finished the arbitration. Morning we had the transcript of 350 pages. After a day gap, we had the final arguments. So those kind of practice is very important to gradually grasp, and once you witness those practices, you realize the difference and what to follow and what not to follow. Third-party funding in arbitration, should India go ahead with it? Of course, see, third-party funding is a commercial aspect, and in a commercial arbitration, if one party is not comfortable, or if it is out of pocket to spend, because international arbitration takes money, it may be 1 crore you're spending to conduct the arbitration fee, counsel fee, witness, etc., etc. If someone is funding that funding for you, and of course he's deriving some benefit out of it, I don't find ethically there's anything wrong, because then, for example, if a party is weaker financially, but if it finds has some merits in the case, why not that happen? Like that, there's a viable option. So in fact, one of my arbitrations on the other side is foreign party. They're getting they're getting a funding from third party, because it's international commercial arbitration, and though it's seated in India, but it has some aspect because of which they're getting third party. So I personally don't find any hindrance to have the third party funding, but laws are slightly different, but it's because you're predicting and earning out of it. So that we need to change the law. She has some questions, sir. In the initial part of your presentation, you mentioned that arbitration is desirable because of flexibility of rules, but institutions engaged in arbitration have their own set of rules which we are bound to follow or not. Yeah, so this question sometimes come because why you are saying is flexibility when you have to accept particular rules. Keep in mind, these rules are tried and tested. It's not that all of a sudden Tom, Dick, and Harry comes up with the rules and say that we follow that. So these rules are in existence. The parties have utilized those rules and have been successful in implementation of both the sides, not one side. So therefore, these set rules are important to follow, because then nothing will go wrong. Like no prejudice will be caused to either side. Don't follow the rules. You go by ad hoc arbitration. You set your rules. Once you come to this field, you will realize what's the difference. Then you will face 100 blockades, because none of them parties will not agree on small things. Compared to that set rules, then you know that this is how it has to happen. The pleadings had to be completed in certain days. No adjournment. If adjournment has to happen, you have to follow particular days within which you have to request for adjournment. So those kind of things, parties set forth the rules. And for example, this adjournment aspect is not particularly mentioned in the rules. What happens if in ICC arbitration, the arbitrator sets out its rules, which are called PO, procedural orders. The first procedural order sets out the rules. So there, the parties agree, and arbitrator says that, if an extension of a time has to be taken, the party has to approach at least 48 hours in advance. Otherwise, your adjournment request will not be allowed. So this is a procedural flexibility where is very important. Otherwise, how to complete the pleadings, how to lead the evidence, those are very set rules. The rules what we have of different institutions, and they mostly follow the similar rules. There may be 20% deviation, but mostly the same rules. So therefore, I don't find anything will go wrong from that aspect. Now, Shreya has asked question, keeping in mind the globalized commercial setting, what are the career prospects one could look out for in international arbitration? In what way it is distinct from domestic arbitration? So, see, international arbitration and domestic arbitration, they operate in completely different field. I have been handling both the aspects, so I can tell you the distinction in terms of procedure, the best practices, what is being followed in international arbitration. So international arbitration also depends who is your other side, who is the arbitrator. There are other factors also, like in one arbitration I faced recently a law firm opposite to me. So I did not find them as efficient to handle the international commercial arbitration, because of which the arbitration was partly conducted like domestic arbitration. So there is a protocol, there's a set practice, there's a set process to be followed. So if someone has dealt with it, then they know the practice. Otherwise, you'll end up making a domestic arbitration only, right? Now, if you look at the prospect in international commercial arbitration, uh, so I'm talking about you're staying in India doing arbitration practice, because that's what I do. Many people, they offer master's degree, they try, they practice abroad. That's one way to do it. If I'm in India and doing international commercial practice, arbitration practice, there you have enormous scope, definitely, because of the reason, not only international arbitration, domestic arbitration as well. Because in my view, arbitration is the future. Arbitration is the future because of the reason that the parties invariably have an arbitration clause. Why? Because they want to avoid the regular standard litigation, court litigation. And if you think about the regular court mechanism, which is called original side practice, like what is original side? The court of first instance, you're going to trial court with your suit for recovery of money. You can go to high court also, depending on pecuniary jurisdiction. So there, the time is a constraint, procedural hurdles are the problem, cost is also one aspect. So keeping those disadvantages in mind, most of the commercial transactions, they have opted for arbitration, and especially the international MNCs, they never go for suit. As I said, that they don't know what is a domestic court setup, so always prefer to have arbitration. So arbitration is the future so far as the original court matters are concerned, right? Sorry, original jurisdiction is concerned. Sorry, so my phone call is distracted. Sorry. Yeah. So having said so, now as I said, that all the contracts will invariably have an arbitration clause. When you don't have an arbitration clause, I have seen clients suffering. So one of my client had entered into an agreement, one-pager agreement with another party in good faith. Some disputes happened. It was a 3-4 crore small amount disputes. There's no arbitration clause. They had to file some recovery suit in Delhi High Court, which went on for more than 5 years. So they were repenting why didn't have arbitration clauses. So most of the transactions will have arbitration clause, and because of that reason, the arbitration has the future. And people have negative thoughts about the arbitration, that it is costly, is time consuming, etc., etc. But I find that this is the most suitable method or medium to adjudicate your any commercial disputes. As I said, the distinction from the commercial arbitrations, once you start doing both, you can distinguish. But what I feel is that if you are into the practice of arbitration, why not to emulate the international arbitration practice, the best practices in domestic setup as well? I try to do that. And once you do that, believe me, people will follow you. They don't reject you, they follow you. I have seen that trend. So once you are following that international trend in domestic arbitration, it really helps the jurisprudence or the practice also to grow. So you also owe some responsibility to the entire area of law. So once you're following some best practice in domestic setup, it really helps. Insofar as law is concerned, it's slightly different. Of course, you are applying Part A of Arbitration Conciliation Act. In International Commercial Arbitration Act seated outside India, you're not applying there. You have IBA rules, etc., what you agree. The things are different, but if you are following the similar pleadings and evidence in domestic and international arbitration, will anyone say that no, don't do that? No one will do that, right? So definitely you should follow that, and endeavor should be like that you should follow the best practice everywhere. Khushi has asked question: given the majorly senior professionals are preferred as arbitrator, what are the major skills that young arbitrator should possess to leave a dent in the said field? Yeah, see, this is a debatable question in the sense now the judiciary is also encouraging the young talents to come up to act as an arbitrator. So there are two aspects to it. Like someone asked me, do you accept nomination as an arbitrator? I said that well, I generally don't do it, but I may choose to do it. What happens once you are active as an arbitrator? I'll tell you this is a professional aspect. So you are acting as an arbitrator to adjudicate disputes between party A and party B, right? So what happens is called conflict. So once you have done that arbitration, then you are conflicted by party A and party B both, right? So that may hamper you the next assignment. For example, if party A only has to come to you as a counsel, you can't take up that assignment, right? There are aspersion raised. So that's one aspect of conflict. But having said so, that's a professional part, ethics or certain aspects of conflict. But there is no embargo to someone to act as an arbitrator, right? Irrespective of age. Now, if I say age, of course, age is not a number. It comes from the experience. So one may have 10 years of experience, but not that much of experience which is required to act as an arbitrator. Now, it may not be necessarily a lawyer. It can be some domain expert, some engineer, some doctor. Anybody can be an arbitrator, right? So it's not only legal experience. Anybody can act as an arbitrator. And when I say that, since I'm talking to you as a legal professional, of course, I will not give a cutoff date. But if I find that of 5 years you are in profession, that gives you a good experience, provided you handle enough number of commercial matters or civil matters to understand how arbitration is conducted. Because you should not be clueless before two counsels what to do next, right? That you should be confident enough to handle. And more importantly, forget about conduct the arbitration also. The arbitral award which is to be passed, that should be a foolproof award. Section 31 gives you an award, what is an arbitral award about, but that's a section. But how to analyze the submissions, how to apply law, and how to weigh the evidence, unless you have already argued, you can't just evaluate and pass an arbitral award. So provided you have that experience, you have crossed that threshold to pass a detailed reasoned award after hearing both the parties, reading the pleadings and evidence, you are entitled to become an arbitrator. And that's your self-assessment, right? That you should know that, well, I can act as an arbitrator. I know how to start the arbitration, I know how to finish the arbitration, and I know how to pass the arbitral award. So that should be the criteria for your experience. Now, Samarth has asked question. Thank you. My question not related exactly to our discussion, but the profession in general. A lot of us here wish to join law firms in initial years and then switch to litigation practice. However, the guidance regarding this is minimal. Can you please discuss your transition from top level law firm to independent practice motivation? Oh, well, so I think I've spoken on this a couple of times in one of the interviews. Frankly speaking, if you look at commercial arbitration, I'll tell you the client perspective, because I have seen both the sides. The MNCs, they prefer to go to a law firm because they find there's a structure. There is a partner, principal associate, senior associate, super junior associate, intern, whatever. There's a set up team, they will handle the matter. If you come to a chamber practice, they find there are only 2-3 people, not sure what will happen, and this, that. So, from client perspective, international commercial arbitration, the big one, they prefer a particular setup, and they sometimes follow Lex Mundi law firms and all. So that's why those will go to law firms. So if you think that one way to handle is that, to know about the arbitration, is that I'll join a law firm, so I'll get to learn about the arbitration. Forget about arbitration, otherwise also maybe litigation, because the question doesn't pertain to maybe particularly arbitration, general litigation as well. So what happens is that the law firm practice in litigation, I'll not name any law firm, but in general, is different than what you practice in as a chamber, because there are pros and cons. So I can't say that is better or this is better. Both have pros and cons. So first and foremost, I can continue for another 15 minutes because my meeting got pushed, and this is an interesting topic, so I'll be able to accept a couple of more questions. Yeah. So so what I was saying is that practice is different because, and there's a pros and cons. A law firm has a typical structure to handle a matter, starting from clearing conflict, allocation of partners, drafting, reviewing, meeting, follow up, this, that, which are, I'll say as a corporate client, they like that, they love it, right? And for any corporate lawyer, client is a god. That's what that's what is being told. So you sort of pray, worship to the client that I'm at your service 24/7. So that kind of attitude is there in a law firm, which one way is good because that gives you a bit of professionalism, which is necessary to handle litigation as well, right? Sometimes people overdo, which is not necessary, but sometimes there's a requirement from client side, so you're bound to do it. So be it arbitration, be it litigation, that gives a structure what exactly has to happen. But most importantly, for example, how to draft email to the client, which may not learn if you're joining a chamber or someone independent, because they don't write emails, right? So it's mostly oral discussions, telephonic or physical discussions, right? So writing of email, how to prepare strategy note, how to convince the client, how to give your professional fee code to the client. Those things are important aspects if you're learning from a law firm, that gives you an exposure and help you to learn to handle a client and manage a matter, right? So that's very important aspects, pros. And once, if you're talking about disadvantages, as I said, there's no disadvantage as such, but it's a perception. Sometimes it becomes too complex because you are running after this procedural stuff only. You are not focusing on the main matter, what to be drafted, but how to be drafted. So that's a disadvantage. If you're coming to independent practice, definitely it's sort of informal. You get more exposure. That's my view. You get more exposure in terms of how to handle of your own everything. You're not dependent on anyone. Anyone in the sense, of course, you're working in a team only, with your senior, with your colleague, with your clerk. You're working in a team, but you get more responsibility, which may be missing in a law firm. So that's one way to do it. Deal with the independent chamber or practitioners, right? So there are pros and cons, but sometimes what I find the difficulty, especially, I must tell you, this is a very interesting story. I don't know if I have to share with someone. So I never thought of joining law firm. It turned out to be that what happened when the campusing started, I just decided I'll go for my independent practice. So, but something turned. I decided I'll sit for recruitment. I only sat for Amarchand Mangaldas. That time it was AMSS. I sat for Amarchand Mangaldas, and interview happened. And you won't believe me, I wanted to shift to Delhi and focus in litigation. So the partner came He interviewed me, so general discussions, not on law as such, but you guys will know that it's more on other aspects. So I had put a condition that I'll be able to accept your offer only if you give me litigation and give me Delhi office. So I had put a condition there, and I was maybe fortunate to get that opportunity, and I have spent there almost more than 11 years there as a partner. But thing is that if you start with a law firm, and if you were going, you're out of station, sort of not your hometown, that gives you sort of economic cushion, because of course independent practice, as you know, is not very cost effective. In terms of initial years, you hardly earn anything. Whatever you earn, you spend in traveling, buying stuff, rent only. You may be dependent on your parents. Sometimes your seniors may pay up more, so that's why you end up joining a law firm. Mostly that's what I felt that those who shift to other city, that's the trouble they have. If you don't have the trouble, uh, I feel that depending on the opportunity, like what law firm you are getting, you should accept it. If you are focusing in litigation arbitration, if you have a law firm, it doesn't have, it's not required to be a tier 1, it may be tier 2, tier 3. If you are able to get that kind of exposure in a law firm, those kind of matters, mixed variety of matters, not only some law firms, they they only do IBC matters. I've seen some chambers that do only IBC matters, so that's a good area of law, but your vision gets completely confined. So if you have a mixture of everything, you should opt for it, like law firm only. Similarly, if a chamber or some independent practitioner has a practice not only in Supreme Court, but he have practice in lower court, higher court, high court, as well as Supreme Court, but a mixture of everything, you can opt for that. So it depends on what opportunity you're getting. But if you have financial aspect is in mind, then definitely you may be compelled to join a law firm initially. But that's not a deterrence, because you are there for to learn something, and take something in your mind when you are going out. It's not that just to earn money you are slogging there. So your independent evaluation, what you are experiencing, how much you're experiencing, and what you're experiencing is very important. So as I said, that opportunity and opportunity and challenges are completely interlinked, right? They Opportunity comes with challenge, and vice versa. So opportunity is there in law firm, is there with the independent practitioners also. So you have to capture it, and thereafter gradually, if you're starting off your own, that has many other aspect as well, but it's too early for you to know that. So you should confine to initial 2 years, right? Do you always encourage your clients to have an arbitration clause in their contracts, or can an arbitration clause be a disadvantage in some cases? I missed one question, come to that. So yeah, I definitely encourage clients to enter into an arbitration clause, because there is always an advantage. I don't find a disadvantage in an arbitration clause. Just then you have to take it from the point of view that you don't have an arbitration clause. What do you do? Think that way. What option you have? You go to court. So you know what your points, what is your advantage, disadvantage, you go to court. So from that perspective, I would always suggest that if the dispute is arbitrable, of course you go for arbitration. There's one more question. In 2010, while hearing a matter related to arbitration, SC has observed arbitration as failed as an alternative dispute. This was mainly because of high cost involved. So this, if you've not missed my talk, I have said initially, cost is one important aspect which is linked to time. So when you're talking about 2010, I only started my profession 2008. Like, so I have done one arbitration from 2008, which completed in 2016, 8 years. So you can imagine the cost has multiple because of the time. So now you're in 2021, when you have a particular timeline for arbitration, so that cost is minimized. So therefore, you can't rely on 2000 Supreme Court arbiter to say that arbitration is a failed mechanism. No, that's not the case as on date. The objective, the way it was projected in 1996 Act was utterly misused. I will say parties only, judges only give interpretation of law. So that's the reason which led to all the delay. But it was never the endeavor or the objective of the act to cause delay in arbitration, which has been cured, and there are procedural infirmity which have been sort of resolved in 2015 and 2019 amendment. With that, I don't agree with this view of 2010. Like if I'm 2010, I would have agreed that. Um, your view on how challenge to arbitration award in courts hamper the entire process in various stages of the arbitration. Parties often approach the court as delaying tactics. No, oh, no, no. So I think it's a general statement. See, it used to happen. Now delaying tactics cannot happen in arbitration because arbitration has now a fixed tenure: 6 months for pleadings, 1.5 years to complete the arbitration, then 6 months by parties' consent. Nothing beyond that. 2 years to finish an arbitration. Otherwise, you have to approach court for extension, right? So the delaying tactics in arbitration is very confined. Don't count the COVID, because COVID has taken away everything. All limitation has been extended. Everyone is suffering. Even arbitration lawyers are suffering. Like if you ignore COVID, now delaying tactics will not help in arbitration because you have to complete within 2 years. Beyond that, you have to go to court, and court can impose cost on parties as well as arbitrator if the arbitration is not completed within 2 years. So that's not completely correct. Now, when you are saying that challenge may hamper the entire process, that's partly true, partly not true. Because see, challenge is a mechanism, is a statutory remedy. You can't do away with that. There are certain grounds under which you can challenge an arbitral award, and that's good, because sometimes what happens, the award may be is so wrong that it should not be upheld at all. I have seen those kind of awards. Now, if you're talking about the court, how it handles section 34, that is also important aspect to see. Once you're in a challenge stage, courts also have a narrow view as regards the grounds of challenge. I'll give a very nice example. Arbitration which I did not handle. uh, uh, I was handling section 34. Party has lost that arbitration, that award is against them. So we filed a challenge in section 34 in Delhi High Court. So there are only very limited aspects. Pleadings was pathetic. So the lost arbitration. Arbitral award is more pathetic than the pleadings. I'll not name the arbitrator. Anyway, so when I was in challenge, I told the client, see, you are challenging, you have only 1 or 2 grounds to challenge. Do you want me to challenge on those grounds or take all the grounds which may not succeed? He said that, well, we'll take all the grounds. So they get super greedy to say that if the award is challenged. So the court went wrong on certain aspects in section 34 as well. That's my view. Not because I have argued that matter, because there's an inherent problem. Section 34 I have lost, and the court has imposed cost on me, because why? I have lost section 34. I pursued it. So it's sort of a deterrence that once arbitral award has come, you try to accept it. You see, you evaluate the arbitration award and don't challenge it. So that's some sort of a judicial view which is emerging day to day. So, and that's really helpful for arbitration jurisprudence, I must say. And lastly, the arbitration is an evolving jurisprudence. So last year the law was something, today you'll find some different interpretation, and it's so interesting. Unless you are involved and completely knowing what is happening in the law and the different stages, you are in trouble. So if you're part of that evolving jurisprudence, I think you'll be happy to to practice it and see how it is progressing after 10 years down the line. So that's what I had to share. It's already 6. Unless someone has question, I can take only one more question, but then I have to close it. Please.
So I think we can wrap the session up now.
Okay, great. So thank you.
Thank you,
so much.
sir, for
Yeah.
sharing the wonderful insights. With that, I would like to just call Parikshit to give the vote of thanks and formally conclude the session.
Thank you, Sujay. I feel extremely privileged to have been handed the responsibility of delivering the vote of thanks to our guest this afternoon. Am I audible?
Yes, yeah.
Thank you. Thank you. Yeah. I'm sure my fellow students will agree with me when I say that we had a fruitful and enlightening afternoon with our guest, Mr. Surjendu Sankar. On behalf of the university, the litigation and clerkship cell, and the student body, I express my deepest thanks to Mr. Das, firstly for sharing his valuable time with us, and more importantly, sharing such valuable and relevant insights and observations on arbitration in recent times. You gave us much clarity as to why arbitration is a very flexible, versatile, and hassle-free form of alternative dispute redressal, while also pointing out areas where arbitration in India is lacking and there is scope for improvement. The point where you said the reduced costs in terms of time consumption as opposed to the monetary expense in arbitration was eye-opening, and personally, I felt that point was stood out for me. You also guided us through the kinds and procedure of arbitration in India. You did all this while sharing anecdotes from your professional life, which I believe was the most valuable pieces of information we will take away today. I'm sure it helped us all immensely. We hope that you will be kind to return sometime later to take another session and share more of your accumulated expertise with us and in further depth. I end by thanking Mr. Das again for joining us this October afternoon and making it an extremely productive one. Thank you.
Thank you. Thank you, everyone.
Thank you, sir.